restrictions. And what the Supreme Court found, well, the Supreme Court went 8-1.
Well, that's pretty dramatic in this with this court's makeup that you would have an 8-1 decision.
And they went 8-1, and Justice Roberts said, you know, we don't want to stifle public debate. And that's the main issue here. Mm-hmm. And, you know, they were in a public place. They were 1,000 feet away, and it was peaceful. So these reasons they're saying this is public debate. We don't want to stifle, no matter how disturbing or, you know,
controversial,
distracting this could be to someone while they're grieving.
Yeah, but see, you can get the feeling of the family that were attending the funeral, and any family attending a funeral for a loved one. So even though a family may be insulted, may be offended, may feel that this is totally inappropriate, they have no right to stop that speech. Isn't that what the Supreme Court found?
Well, they said even deeply offensive speech is protected.
Yeah, but I understand that there are a variety of speeches that are prohibited. And the First Amendment doesn't give everyone the right to say whatever they want, but obviously this must have fit into the area where it's just freedom of speech. It's not fighting words. It's not words that are inappropriate, like in a theater when you yell fire or things like that. So in fact, it fit the guidelines of what the First Amendment really expected.
Well, that's been evolving. You know, fighting words aren't what they used to be. Fighting words used to give a lot more latitude to the person to whom the fighting words were directed.
Right.
It used to be that, you know, if you insulted someone and said certain words that were classified as fighting words, the person could react, and that would be a defense.
Yeah, but what words are still existed that are even considered to be fighting words that you could justify that?
I can't say them on camera. I think we signed something.
We signed a contract to ensure that we don't fight each other.
We can't say those. But there are certain things that someone could say that are meant to, certain insults that would be meant to elicit a reaction. But I'm just saying that those are less and less protected than they used to be.
Well, so what effectively you're saying, the Constitution is evolving, even on the freedom of speech. And it sounds as though things that are lies, offensive, that any normal family or normal individual could take total offense to, but there's still, somebody has a right to say them to your face and effectively get you to react. Is that what you're saying?
I'm not sure if it's to your face. But even now, I think, yeah, people can say things to your face that in the past you could have rightfully fought them or dueled them or, you know, hit them in the nose or something like that. And, you know, your defense would be, well, they incited me with fighting words. Now we would be mitigating, but it wouldn't be any kind of an affirmative defense. And so you would still, in a criminal case, you would be guilty, but it might be a mitigating.
Well, you know,
which is not much.
You know, in the state of California, they have a clause called it's 457 of the Civil Code. It's a anti-slap code that's very unique to California. That it actually establishes the fact that you can say whatever you want in a court surrounding or administrative hearing, and even if it's a point-blank lie, you're protected. And if somebody files a lawsuit for defamation or to prove that the words were in fact false, the person that filed the lawsuit can be held responsible, and all attorney fees would have to be paid by the person that instigated that lawsuit. So the Constitution, under that has actually evolved in California to a far punitive state.
Well, that's an interesting procedure. What they're saying is that we want the courts and these public forums to be protected in a way that you wouldn't be outside in the public.
Well, I got to tell you right now, if you're on the outside telling point-blank lies and you're accusing somebody to be a murderer,
be slander, yeah.
Slander, you'd be able to fall under defamation and slander. But like I said, in California, they've actually tried to make the Constitution more with a punitive bite to it, so to speak.
Yeah, well, California has some interesting statutes.
Yeah,
it's on the forefront of many different statutes that other places you wouldn't see.
And well, the slap statutes in California are actually very unique to California,
right.
And I believe there's only one or two other states that even abide by that. But they did what the legislature did in California. It has expanded the First Amendment and said now we can take a bite out of you financially.
But I think also you're talking about like in settlement negotiations, you can say a lot of things that you wouldn't be held accountable for.
Exactly.
And I think it's an expansion of the thing where the court is they want to have things hashed out in a fairly quick and expeditious manner. And so will put up with more rudeness than you normally would have.
Right, exactly. In fact, with the courts, they want people to be able to have a freedom of expression, even
Right.
if that freedom goes to a point that may not be correct. Well, listen,
Okay,
Mark,
well,
on this,
there's one other thing.
Oh,
If
yes.
we have time, we still have a little time in Constitutional Corner. There's Judge Vincent tangled with the Obama administration again.
Yes, and I understand Judge Vincent actually reacted to the Obama administration's slow feet in filing an appeal.
Well, it's kind of I think it was kind of a backslap. What happened here? No pun intended for the last subject, but generally when a federal judge makes a finding, the U.S. government would consider that an injunction and stop in their tracks. But the Obama administration just kept moving forward on Obamacare despite this finding that Obamacare was unconstitutional. But instead of reacting to that, Judge Vincent took a kind of creative approach and said, okay, yeah, go ahead and keep doing this. But I think your arguments for doing that are bad faith arguments. I think you're stringing out the legal process and you're being dilatory, using dilatory tactics. He said something about borders on misrepresentation.
Right.
And he said, okay, if that's how you're going to try to twist my words or whatever, you're going to try to change the meaning of English words, then, okay, go ahead and do what you're doing, but let's expedite appellate review.
Well, actually, Mark, what I'd like to do is I'd like to hold that because that's the appellate brief is supposed to be filed by tomorrow, actually.
7 days is not much time.
And I will tell you, in our next show, I think we're going to have to cover whether or not the administration actually followed Judge Vincent's order. But at this point, I think it's time for our next topic. What's our last topic for the night?
Well, our next topic is Chevron got in a little hot water down at the equator.
What? Well, the equator is a good place to get into hot water.
So,
but what happened?
So Ecuador is saying that Chevron owes these plaintiffs in an oil spill suit $8.6 billion.
Are you trying to tell me Chevron had an oil spill in Ecuador?
Well, the funny thing is Texaco was drilling down there.
Wait a minute. What does Texaco have to do with Chevron?
Well, it's kind of like the same way Bank of America has something to do with WAMU.
Oh, because Bank of America bought WAMU, so you're saying that Chevron actually bought Texaco, and Texaco had oil drilling in Ecuador.
Right. So they kind of, and apparently their lawyers didn't do an indemnification clause or whatever, or they weren't aware. They didn't take this liability seriously when they bought all of Texaco.
So they bought the worldwide assets of Texaco, and as a point, Texaco had previously done drilling in Ecuador,
right,
from what I understand. And there had been a lawsuit filed, I believe, 17 years ago against Texaco prior to Chevron acquiring them. And then at this point, this was all over oil spill, so to speak, in Ecuador, allegedly created by Texaco. Is that the basis for this?
What the plaintiff said is that there was an oil spill in the rainforest, ruined virgin rainforest, terrible harm, not only harm to the forest itself, but harm to the community. And so some of the money would be to the community to repair itself. Some of it would be to try to, repair the environment and that kind of thing. But I think possibly, and this is just conjecture, is that maybe, Chevron thought, well, since Texaco doesn't really own anything, because I think the land had gone back to the government, or Texaco was no longer holding assets in Ecuador. Chevron was thinking, well, Texaco doesn't even have assets. What could the government encumber in Ecuador?
In fact, what I believe what it was Texaco was I believe in leasing agreements with the landowners, and so that was their presence that allowed the justification for the Ecuadorian government and the plaintiffs in this case, because it wasn't the government that was suing; it was individual plaintiffs, landowners that were suing Texaco originally, and because of the leasing and the oil spills, allegedly caused by Texaco, that was the basis for the lawsuit. Because in Ecuador, you cannot file against a defendant that doesn't own land or have a commercial or a contractual obligation to any land in Ecuador. So in this case, Texaco originally had a leasing agreement, and I believe that's where the oil spill case originated.
Yeah, and so the question is, of course, if you lease or rent, you're owner of that land while you're paying the lease.
Exactly.
But once the lease is up, are you an owner of that land? So that's a technical question. But even a more interesting question, as you brought up, is you're saying the plaintiffs weren't the government. Well, Chevron doesn't look at it that way.
No, in fact, we know how oil companies notoriously have a cozy relationship with most governments. Not so much in Venezuela anymore.
Not with Venezuela. But see, Chevron is alleging that the government, the prosecution and the government and the judges are colluding with the plaintiffs.
Well,
and they're saying it wasn't a fair trial.
Well, I understand that actually the chief prosecutor and several of the judges, because this is a multi-judge case, were actually caught on tape, once again, caught on tape, working with the plaintiffs and guaranteeing results that would have been a counter to Chevron's position.
Well, okay, so Chevron's saying that this ruling, it's a contrary ruling to Chevron. It's a good ruling for the plaintiffs, for the Ecuadorians.
And the government, because the government's intending to take about 40% of the cash award.
Okay, so the Chevron is saying this ruling or this finding is a product of fraud, and it's contrary to scientific evidence. And even under Ecuadorian law, Chevron has a short reprieve because under Ecuadorian law, there's no payment until Chevron gets a chance to appeal in Ecuador.
Well, you know that this ruling did not come down until the Ecuadorian people elected a populist president, because up until then, the Ecuadorian government had kept their hands out of the case, so to speak. And after the election of a new president, the ruling came very quick, and it actually was an $8.6 billion ruling against Chevron. Fortunately, even under Ecuadorian law, Chevron owns no land in Ecuador, so there's a basic premise that they should not be able to be sued to begin with. Secondly, The Hague, which controls international lawsuits, had put a stay on any payment. And then lastly, a New York federal judge said that there's going to put a stay on any collection from any Chevron funds that are even found in the United States. So even if our administration decides they wanted to pay or force Chevron to pay, there's already a federal judge that preempted that in advance, knowing that there's a chance that the Ecuadorian government would come to the United States with that full faith and credit basis that we've talked about before and try to collect.
Yeah, well, there's an interesting legal issue on international trade about this full faith and credit, whether there's a treaty and how you would actually effectuate collections. I mean, it's one thing, as you know, many times you win a lawsuit, and that doesn't make much difference because you got to collect.
It's a piece of paper, Mark.
Yeah, you collect. So, okay, well, yeah, you're right. Okay, under Ecuadorian law, they get to appeal. Chevron does. There's a federal judge in the U.S. in New York that issued a temporary stay on any monies coming out of any New York banks or coming from Chevron there. Okay, there's also The Hague that says they're going to block any ruling on collection worldwide, either in Ecuador or anywhere in the world, until a panel rules on this in The Hague. And so this court in The Hague is something that I think is getting an interesting subject that we ought to look more into.
Yeah, in fact, Mark, I'm going to tell you, we're coming to the close of our show tonight, but I wanted to tell you right now, The Hague, we could spend a whole segment just on The Hague alone, because they have law that they're trying to impose on every government in the world, and only by us submitting to those decisions puts the U.S. into a change in its ability to enforce its own laws.
Well, Justice Kennedy spoke on that, yes, about using guidance for international law and, kind of pushing our Constitution out of the way and kind of using it. But the Hague is getting more powerful. There's no doubt about it.
And I will tell you, we're going to come back and visit The Hague in one of these shows. And tonight, I'd like to thank you all for joining us for Law Talk. And for any questions out there, you can always email us at our noticed emails, and we would be more than willing to share our thoughts on those subjects. Thank you, Mark.
Okay, well, it was good having you.